everybody. Tom DeVore and Mr. Bryan Drew here, coming to you on the assault weapons ban in typical fashion. I got a T-shirt on, and Mr. Drew has on his suit, so he's always looking sharp. I like that about him. I just like to be an old hillbilly. Thank you for joining us. Most of you know that this afternoon at 1 o'clock we had our hearing on our motion to reconsider over in Effingham County. Mr. Drew and I both argued that on your behalf. Took us a couple of hours. The judge took it under advisement. He will issue his decision in probably a week or two. I don't really know. There's no specific time frame. I assume sooner rather than later, but we don't really know. But as soon as we get that, we will let you know. The essence of the argument that we made is that the court should not have dismissed our case without giving us a chance to have a hearing, because we're arguing that some of the exempt categories of persons are similar to ordinary citizens, and that they're not really protectors of the public, and they don't have any specialized training, things of that nature. It doesn't really serve us any purpose to get into those details. But, you know, we argued that under any set of facts, we should have a chance to present those facts. And the court didn't give us a chance to present the facts. One of the things that I thought was worth mentioning to you is it seemed clear for the first time, at least by listening to the Attorney General's office argue on behalf of the state, is that they really are using the Caulkins decision heavily.
Yeah.
Look at Bryan smile. And it's important to know. I want you guys to know, and I said it today after the hearing was over, that, sorry, my phone beeped up there. It was an attorney asking a question about this case. But it's important to know as it relates to the Caulkins matter. The lawyers, and I told them after the court case was over, the lawyers for the Attorney General's office are just doing their job. They're not bad guys. You know, they're arguing the opposite of what we're arguing, but they're not people to be hated or talked down about. Again, they're not legislators, they're not politicians, they're just men doing their job. But one of the things that I thought was interesting as we talked after the hearing was over is there was a little bit of prodding about Mr. Dan Caulkins. And I'm not going to sit here and pound on Dan any more than I already have. But it was not, there was no secret. I want to make sure I say this as politely as I can. There's no secret that they were pleased with the fact that Mr. Caulkins was so gullible in giving the state everything that they wanted to really stick it to the gun owners of the state of Illinois. Is that a fair representation, Bryan?
Oh yeah, absolutely. They set it up. They set he and his attorney up, and they just fell right into the trap. Didn't do any evidence, didn't do discovery, and rolled right on up there and and then they turned around and did exactly what their intention was all along, which was to then use the Caulkins decision, because a facial challenge is nearly impossible. It's a nearly impossible way to find a statute unconstitutional. He moved forward on it, and they got him to move forward on it for the purpose so they could then use it against us, because we were the ones that they didn't want to fight against, because we were going to ask for discovery. We're going to depose the Speaker of the House, the President of the Senate, the governor, and they don't want any of that coming out of how this went down. So
exactly. And and again, talking after it was over, there was a brief discussion. Again, this is just conversation about how, you know, our case could have been the one that went to the Supreme Court. And we started, Bryan, at least I was laughing. I think Bryan was too. It's like, yeah, we weren't going to do that because we knew we would lose, just like Caulkins lost. And again, the commentary briefly was how easy it was to convince Dan Caulkins to do what they wanted. And now that that case is over, I mean, they don't care who knows that, right? I mean, it's nothing can be done about it. The case is expired on Caulkins. But, you know, I want people of the state to know that the governor and his people think it's funny that Caulkins was so stupid. That's the gist of it. And that's not a criticism of those men, because they played their legal cards very cleverly, and they found an idiot that played along with them. And that's all I'm going to say about that. And again, it was a joking 30-minute conversation about what they thought of that, and it was worth mentioning to you guys because we've got 2.4 million gun owners in the state, give or take, that have a FOID card that could have, prior to this law passing, bought an AR platform and some of these handguns, the banned weapons, let's call them, all they wanted. Now they can't. An argument that we should have never been arguing because Caulkins tried to be a big shot. So 2.4 million people have been harmed in this state because of vanity, whatever you want to call it. And, pisses me off, but I can't do anything about it. So as to the case, we argued to the judge that we should have our day in court, irrespective of what Caulkins did. That's really what we argued. I mean, the judge took it under advisement. So what's going to happen now? The judge agrees with us, and the case comes back alive in Effingham County. And if it does, we then continue with our discovery requests. And if we can get to discovery, I think we have some very significant chances of being successful. I've always thought that all along, or I wouldn't have asked people to hire us to take this case on. But we have to get to that fact-finding process. And again, it's always been the desire of the governor and the attorney general and the legislators to never let us get to that fact-finding process because they know if we do, they're in trouble. But if the judge refuses to accept what we argued and denies it, then we have to go to the next step. We have to go to the appellate court and ask the appellate court to overturn the trial court and say that the trial court made a mistake by not letting us have our evidence and our fact-finding mission. And then it would come back to the appellate court or to the trial court for the appellate court. Now that process, guys, I hate to tell you, we could ask for expedited. It could take 6 months to a year. I mean, it's not going to happen quickly if we have to go to the appellate court. But we won't know the answer to that until we get a ruling from Judge Jarman. You want to add any more on as it relates to that process, Bryan?
Oh, well, what we essentially asked for today was the court to reinstate the case, which he did of his own volition, thinking that our claim was the same claim as Caulkins, which it's not. And it's a very technical legal argument that we made today. And at least from the standpoint of it's a facial unconstitutionality objection based on an as applied. So basically as applied means that our plaintiffs, the 7,000 people that we have, that some of them are in the exact same position of some of these specialized categories. And if we show that, then the categories are out. And if you do it enough and you get to the point where the statute's basically been gutted, at that point, they could conceivably throw the whole statute out. So that's our angle, and that's a fact basis. And I think one of the biggest things that Tom and I brought up to the judge today is that it's reversible error to not give us our hearing. And that's all we asked for. We said, Judge, look, these 7,000 people deserve their day in court. They get to put on evidence. And when our evidence and that's why the state so desperately wants to stop it, because they know once we get the discovery, once we get the evidence, it's not going to go well for them. And so if they can hold us off or stop us altogether, that's their plan. But if the judge should reinstate our case. He should reinstate it. We should get to go finish the discovery, have our hearing, and that we can do in an expedited manner. But you're right, Tom. If the judge says, no, you're out, I mean, I think it'll come back, but we have to go all the way to the appellate court, 5th District, and then come back and then start through the discovery again. It's already been delayed nearly, 9 months, and now we're staring down longer if he does it that way. So it's frustrating.
Somebody just asked the question, does the TRO get reinstated if the judge reopens the case? And the answer is not necessarily. The judge can take those two issues on independently. So the judge could reinstate our case and rescind his dismissal order, but he could refuse to reinstate the TRO and leave it dissolved. That's a possibility. He can do that, absolutely. A decision to reopen the case does not mean that the TRO gets reinstated. But I would say to many people, that TRO was in place for months. And if you didn't buy what you wanted to buy in those months, then, maybe you should have taken advantage of that. But no, it doesn't mean that it will be. It could be two completely different things. The judge argued that they shouldn't reinstate the TRO because he shouldn't reopen the case. They were kind of their arguments were conjoined. Is that you can't reinstate the TRO because you can't even let them stay in this case because Caulkins forecloses any chance for them to argue. I'm going to try, I'll try briefly. There was a question over there, to explain it. The Caulkins case, that since it didn't have any facts, went to the Supreme Court. And really what the Supreme Court of Illinois said, whether you agree with them or not, it doesn't matter, is that if you are a public employee and you have a duty, and that's a legal term, you guys, you have a duty to protect the public, to keep the public order, to arrest people, to prosecute people, to incarcerate people. If you are charged with that duty, and with that duty, there's training that goes along with it, that you are different than an ordinary citizen with a FOID card. And that way, those people that are charged with that public duty and they have that training can be exempt from this law, even though a FOID card holder is not. Now, I'm not asking you to agree with that. It doesn't matter. But what I'm saying is that is what the Illinois Supreme Court said. And that is the law of this state until otherwise they might rule, or the federal courts might overturn it. But in Caulkins, where they failed is that they didn't get into the facts of these exempt categories, and they didn't get into the facts of the plaintiffs. And the Supreme Court took for granted that all of these categories of persons have a duty to protect the public and to protect the public order, and that they are adequately trained. They didn't question it, because guess what? Caulkins didn't question it. And what we said to the judge is our case is different than Caulkins because we're questioning it. Does that make sense, you guys? We're questioning these issues of, are you charged with a duty to protect the public? And are you adequately trained to make you any different or special, if you want to use that word, than an ordinary FOID card holding citizen? We're going to dig into those details. One example that we'll give you that we know we can win is retired law enforcement officers. Not an active duty law enforcement officer, but a retired law enforcement officer. A retired law enforcement officer has no duty to protect the public. Their law is clear on that. Once you're retired, you have no duty to protect the public. You're like an ordinary citizen. So how can you say they are exempt when they're retired if there's no duty? Those are the arguments that we want to make in this court. It's one of many. And it's the arguments that Caulkins should have been making, that I pleaded for him and his lawyer to make, because if they didn't, they were going to lose. And that's why we're asking us to have the court to have our day in court. Go ahead. Were you on anything that, Bryan?
Oh, no. I mean, it's clear. I mean, when you start getting into these exemptions they have, a lot of the things the government argued both in the Caulkins case and ours, just simply not true. I mean, they say all these people have this duty to protect, and they simply don't. I mean, and it's just not true. And so it's really unusual that the Supreme Court just took these things as facts without, I mean, when there's some statutes that and case law that's specifically there and shows it. So, I mean, it's kind of a lack of an argument made by, Caulkins counsel, where he should have jumped in on that and said, hey, here's all these cases that say you're wrong. Yeah, that's not the case. But unfortunately, that wasn't argued. The Supreme Court missed it. And now here we sit with all these arguments at our hands, ready to use them as we always have, and just asking for the opportunity to get that back before a judge. And I think we went on several of them. And I think really we could probably, gut this law to the point where it might be possible that the court simply says, look, I can't separate these things out anymore. This statute's just no good, which would be, the best of all circumstances for us.
And even if we accept for conversation right now the Caulkins holding from the Supreme Court, and we have to, it's, at least for now, it stands for the proposition, only stands for the proposition, that if a public employee has been charged with the duty to protect the public, and at least for now, let's say that's active law enforcement, you're a law enforcement officer and you're currently employed and you're doing your job, that you have a duty to protect the public. Again, there's some that'll say, well, you don't have a constitutional duty and you can actually not. I understand what you're saying, but they do have some duty to protect the public. You will lose the argument of saying law enforcement doesn't have a duty to protect the public. You'll lose it in these cases. But let's give it to active law enforcement for conversation. Let's give it to active military for conversation. They have a duty to protect the public order for conversation purposes only. Those are the only two. Retired law enforcement does not have a duty. Corrections officers and prison superintendents and prison wardens don't have a duty. Mall cops, private security contractors don't have a duty. All of these categories in the statute that the Supreme Court of Illinois didn't even look at because Caulkins left it out, none of them have a duty to protect the public order. So under the analysis that we have done and that we will get presented at some time, you throw all of those categories out and you may be left with active military or active law enforcement officers, maybe, and active military, maybe, that's fine, during their public duties. If that happens in Illinois, this law is going away because the political capital that will be lost if you throw all of the public union, retired law enforcement, and prison wardens and prison guards, you throw them all out, say, sorry, guys, you lose your rights too. This law will collapse on its face because that political capital will put too much pressure on this legislature. I guarantee you that'll happen. But as of right now, with Caulkins letting them do what they did, they got an order from the Illinois Supreme Court that didn't address any of those issues. Didn't address them at all, even though you got the governor trying to say, oh, they addressed them all. No, they didn't. They didn't address any of that stuff, which is cleverly what they wanted to do. And even Bryan today, when he argued in the court at the end, said they were very clever in their arguments. But, you know, these are good lawyers. They're sly like foxes, and they'll do those games if you let them play those games. And we don't let them play the games, but they got away with it, at least in the Caulkins case. So somebody said, is a 3 readings rule and the other procedural things still at play in our case? The answer is yes. Yep. Those issues are absolutely still in play. But we have to be able to get back in front of the Illinois Supreme Court to make those arguments, because guess what? Caulkins gave those arguments up too when he went to the Supreme Court. And the Supreme Court in the Caulkins case actually said, you didn't bring those issues to us. 2 justices in the Supreme Court of Illinois actually wrote that this should be a 3 readings rule issue, and this case should fail, or this bill should fail for that reason. And the majority said, oh, sorry, they didn't bring that issue in front of us. They didn't appeal that issue, and they didn't. It was foolish. So, yeah, but that issue is still alive in our case. Let me see here. There's a couple of other ones. Somebody's talking about training over there. You know, keep in mind, according to the Supreme Court, it's not just training. You have to have that public duty to protect and the training. And the public duty to protect, again, you have to look at that. You know, is there an actual duty under the law someplace? And again, absent maybe law enforcement and military, current law enforcement, not retired, I don't think any of the exempt categories have a duty to protect the public. And that's one of the arguments that we're trying to make.
Well, and just think about, I mean, some of the categories are just nonsensical. I mean, if
the Smurf suit, somebody just asked about your Smurf suit, Bryan.
No,
who said that? Justin? I agree with you, Justin. That damn fancy ass Smurf suit. I love it.
Hey, you know what? My wife likes it, and and when we're done here tonight, I'm going home to her, so I'm not worried about.
He ain't going home to you, Justin. He's going home to his wife, and she loves the Smurf suit. Go ahead, brother. Sorry, I had to say that.
Oh no, it's fine. You know honestly, they'll think about it. Just they didn't think about this law at all. It's so nonsensical in every way. So a security guard gets his or her right to carry a weapon while they're working. So they go buy an AR-15 because, well, their employer's not providing it to them. So they go buy one. Then a year later, they say, I don't like this job and I'm not doing it anymore. What do they do with this AR-15? They aren't part of the grandfathered group because they didn't acquire it prior to January 10th of 23. So they're not part of the grandfathered group. They only got to possess it and or use it while they were working as a security guard. Now they're retired. They now have a piece of property that there's nothing they can do with it. They can't sell it. They can't distribute it. And frankly, probably just simply possessing it at this point is a crime. I don't know where they go from there. I mean, that is a problem throughout. I mean, there's so many problems with all the law, and it's just frustrating that we have all those arguments to be made. And the other case ran up there with no evidence, where when all this evidence, because if we'd have got to make, the problem is the facial argument could have come a little differently had all these facts been brought out and the arguments been made differently. Because I still say the Supreme Court's wrong on the facial argument. that it's facially okay. Well, because these police officers, but that's a pretty big stretch. And still, I think we could have made some pretty good arguments the other way. And I think combined together, it would have been even stronger.
Couple of things. Somebody said, can we refile something regardless of this case in Effingham County? The answer is yes. We're not going to talk about that right now. Bryan and I are actually working on a few things, but simply speaking, yes, the answer is there is a possibility to do that. Somebody said, can I comment on the plaintiffs there today? What do you think, Bryan? We probably had 150 people there, maybe inside and outside the courtroom. I mean, there was no other places to sit. We had maximum capacity inside the courtroom, and the deputy said that we couldn't let any more people in, and there were still at least 50 plus people standing outside the courtroom. So it was a very good turnout. And again, I appreciated that.
Oh yeah. I like to thank everyone that came out. I mean, it's kind of nice. You know, it's nice to walk into a legal argument and have that many people there supporting you and supporting what you do. So really appreciate all the people that came out today.
I got another Smurf comment. It says, tell Ryan to split the screen over/under. The Smurf suit is under the comments.
I mean, that's it. All right. I'll take the coat off and we'll leave it at that. How's that? Can we do this? All right.
Let's talk about the registry for a second. And I'll thread that needle the best I can.
Yeah.
Last I heard, as of December, because as you had to by what, January 1st, you had to file if you have an exempt or a banned weapon. If you have a banned weapon, you had to register it by January 1st. I think I heard as of the end of the year, there were 29,000 and some change registries. And so I've talked to some people within some lobbies that said the governor and these legislators, these liberal turds, are all pissed off because we've got 2.4 million gun or FOID card holders in Illinois. If we estimate 50% of them own something that could be banned, I don't know what that is, then that's 1.2 million of these weapons, or 1.2 million of these citizens, and they've got 29,000. And I just had a phone conversation 2 hours ago that they're all sitting around trying to figure out what they might do about that. I mean,
currently
the law says you had to register it. That's what the law says. If you chose as a citizen not to, that was your choice, right? I mean, you do what you think is best for you. The issue is now is, and Bryan and I talked a little bit about this, is this what is today, January 4th? I mean, if somebody, hypothetically speaking, and we're purely being hypothetical here, if somebody filed that, and I don't do really a lot of criminal law work, but if somebody filed that affidavit today, is that technically an admission that you didn't file it on time because it was supposed to have been filed before the first of the year? So, you know, if somebody made a decision not to file one within the time frame, I don't know that filing one right now would do anything but admit guilt. But I'm not a criminal lawyer, but it's an interesting conversation when there's only 29,000 of them. So,
well, and I mean, the bigger portion is now, I mean, as it relates to the registry, I mean, how harsh is the government and Kwame Raoul at the AG's office going to enforce this? I mean, that's the question.
You and I debated that. I don't think they can.
Well, I mean, where do they go from here? Because Kwame Raoul when all the sheriffs said, hey, we're not enforcing this law, Kwame Raoul put a statement out that said, hey, if they don't enforce it, we'll find somebody who will. And we've got word from several places that the governor's trying to put together some state police task force together to try to look into this stuff. So, and I mean, it's going to get, I don't know where they're going with this, but it'll be interesting.
Are they going to find a state's attorney outside of, let's give them Champaign County, because Julie is an interesting person. Give them Lake County and give them at least Cook County. There's 3 counties where you might have a state's attorney that would have the gall to bring one of these charges, if you even could put a case together to prosecute. You get into overwhelmingly a lot of these counties, these state's attorneys are going to be in a tough spot, right? Because they're elected by the people of that county. And I can tell you what, you come down in here into God's country, where we're from, right, Bryan? I mean, where we're from, and start saying, hey, Mr. or Mrs. State's Attorney, state police did an investigation, prosecute this person, and go, okay, Scooter, let's see how that works out for you. Because then you're going to have to find a jury to convict them. Good luck with that. And then you're going to have an election. So, I've never been one that goes out and promotes mass disobedience in any fashion. I've never said a word about it, but it seems like that's what's happening at this point, potentially, at least from the math. I don't know what J. Bob's going to do about it. I mean, I know they're sitting around steaming about it, but I don't even know. I don't even know how they would put that case together. How do you have a citizen out in the world, one of the 1 million to 2 million citizens in Illinois, and you think they might have one that they didn't register? And you think they might have it at their house because maybe they had one and took it to a family member in Utah. Hell, I don't know. And they got it out of their possession, gave it to a family member, or did something before the affidavit. I don't know what they did. But again, I'm not a criminal expert, but man, I would love to see some good criminal lawyers take a swing at that and say, come on, you want to try to prosecute this? I mean, leave the political ramifications for a state's attorney out of it. I don't know. I mean, I think that from a political perspective, Bryan, it's one of those situations to where you get legislators and executive officers pushing these agendas way outside the realm of accepted norms, even though you've got polarization of politics on Republican and Democrat, conservative, liberal. Most of the people run in the middle someplace, and you start getting out on the fringe either side and passing legislation that offends the overwhelming majority that sit around and usually don't say much, you might have stuff like this happen. So it's going to be interesting to see what they think they're going to do. But 29,000 registrants looks to me like mass disobedience. I don't know what else to call it.
No, and somebody asked a question there, well, even some states' attorneys are now waffling a little bit and saying, well, if there's an underlying felony, we may enforce it. And, the problem there is they come to your house for some reason. There's a reason they come there. They're investigating a crime. They're investigating something. And in the process of doing that, they observe a weapon. Well, now it isn't going to be that hard to find out if you're on the list or you're not on the list. If you're going to shoot it, you're driving somewhere with it in your car and you get pulled over for a reason and they see it sitting in your car. Now they got your name, they got you with the gun. I mean, now you're right. I don't think anywhere south of I-80 except, I don't know the state's attorney in Champaign County, but I don't know anybody south of I-80 who's going to prosecute this. So then the question becomes does the Attorney General's office have jurisdiction? Typically, the Attorney General defers to the state's attorney and says, well, do you want to prosecute this? Are you okay if we come in here and prosecute this? Which I don't see any state's attorneys south of I-80 saying yes. They're all going to say absolutely not, stay out of my county. But do they have the legal ability to come in and prosecute it on their own? And then if they do, I mean, I think they're going to have some serious problems with proof. But you can certainly charge people. You can certainly charge a whole bunch of them because all the ARs that have been sold, there's a record of it. There's a record of who bought it, who has them. And then it just comes down to whether or not you still have it or not. And then you got to find 12 people to convict you, which I think is going to be next to impossible down here as well. But, the problem is that you've just taken thousands upon thousands of law-abiding citizens and told them on January 1, if you don't sign up on our list for exercising your constitutional right, you're a criminal. And that's just, I just can't think of anything worse. You know what? If they go and take away all the illegal weapons that are in the hands of every criminal in the state of Illinois first, and they got rid of every single one of them, then come back and talk to me and talk to us about all of us law-abiding citizens who have our weapons. I'm not going to give them up, and we're not going to agree to because the Constitution says what the Constitution says. But at least go try to take them from the criminals first before you try to take them from law-abiding citizens. It's the damnedest reverse thing I've ever seen is we've come after law-abiding citizens for their weapons they have. I mean,
I agree completely. Somebody said, can the Attorney General supersede the state's attorney? And the simple answer is no, they cannot. So there's some circumstances where an Attorney General can prosecute a crime, a general crime like we're talking about here. But it's very specific. It has to be a very complicated set of facts. And if the state's attorney comes in and says, this is my case, I'm taking it and I'm going to deal with it. Bryan and I have talked about it. They could take the case and just do a really shitty job of prosecuting it, and the person's going to get off anyway. So the simple answer is no. Okay. There was a couple of other ones here. Somebody said they had a boating accident and lost their weapons. I've heard that one a couple of times.
I've heard that one. I've heard some people said they misplaced them and they don't remember where they were at.
It is true that your FOID and CCL is tied to your driver's license now. I've had a couple of cases to where you run a driver's license, they'll tell you what the status of your FOID is. So yeah, that is being done. And Bryan probably knows a lot more about that than I do. Somebody said, what did they say? Oh, somebody said something about me calling you the nature boy today in court. Yeah, he looked like, Ric Flair in that fancy suit, styling and profiling he did. I did call him the nature boy.
I get a little fired up in there. You gotta.
Yeah, he does.
Have a little flair.
He's more dramatic in the courtroom than me. I thought he was going to break down on one knee and shed a tear there on his closing argument.
Well, it's important stuff, as we, we've talked about.
Oh, it's serious as hell. I'm trying to make light of it right now, but you don't want to get me started because I'm fucking pissed. I just not trying to go down that path. If I had my way, I'd tell JB we'll go in the octagon and deal with this, but I probably get in trouble.
Well, they might be frowned upon, but no, it really is just it's just the games they've played with this whole thing. And what's worse is all of this is for the absolute most horrible reason in the world, because none of these laws are going to stop anyone from using the people that are using these weapons illegally. It's not going to stop a single one of them. They're not registering their weapon. They're not abiding by the law to start with. So it's not going to affect a single one of those people. They're not going to stop any shootings. They're not going to do anything with it. This is all just a big bunch of bull for JB to pad his resume because he has a pipe dream of running for president of the United States. And if he can if he can get his big liberal pipe dream agenda through in Illinois, then he thinks he can sell this to the rest of the liberal states in our country. And the problem is he's just laying waste to the Constitution and attacking good law-abiding citizens for something so ridiculous like his personal desire to be the president. I just can't think of anything worse than that. I mean, just for this selfish desire to do that. And that's the worst part of all this, really. But
well, there's no doubt about that. He's doing this I don't even think JB gives a damn if the law gets overturned. Nope. He can still, if it gets overturned by the court, he's still got his street cred to go to the legislative politics on a national scale. I agree with that absolutely. Somebody said you look good in your blue suit, and I was just jealous, but I'll let the record reflect. I also had a blue suit on. It just wasn't baby blue.
Well, I had to mix it up a little bit. I couldn't wear the same one you had. I mean,
and somebody said they wanted to know if you went, woo!
I can. And I've done it in the courtroom.
You can't do it like the nature boy, can you?
Nobody can. I mean, that's a specific thing.
Let me see here. I'm trying to see if we got any more. Now they're telling you to put the jacket back on because you're blending in with the white wall behind you. I'm like they give you shit, not me.
I know, right?
Yep.
That's all right.
Let me see here. There's a few people talking about, well, they're going to come and take them. They're going to come and take them. It's kind of like when we had the business closures in the mass. The big phantom boogeyman was going to come hither and, smite them. And I'm like, really? Can you explain to me how that's going to happen? So,
yeah, I mean, logistically, I have absolutely no idea how the state of Illinois, with the limited number of state troopers they have, because I think if you come down to sheriff departments, good luck with that. I mean, enforcing this registration law and checking into people's homes and arresting them. I mean, with the limited number of state troopers they have, I just don't know how they can really mount much of a thing. But what does Attorney General, what's Kwame Raoul and JB Pritzker do with this? I mean, basically 90-something%, 98, 99% of the people who own an AR said, no thanks to your list. I mean, that's statistically looks like a fact. And at this point, that means their law, they enacted it, and everyone said no thanks. So, it will be interesting to see where it goes. But I mean, I've done some criminal defense work in my life, and my only comment will be, if the governor wants to come down and the attorney general want to charge a bunch of people with not signing up on the registry, come on down, lace them up. We'll throw 12 local Southern Illinoisans in the box over here, and I think we'll have not guilty verdicts roll out one after the other. So, see how they want to do that. But
And no, I mean, again, last question I'll answer is I know of no way that if this law is overturned that you might sue for lost profits. So I'm not saying it doesn't exist. I'm just saying I don't know of it. There might be some 1983 federal action or something, but that's precarious at best. So it's one of those things you get when you live in a state that's riddled with an inept legislature. It's what you got. I mean, you're really the legislature in Illinois. It's inept. I mean, they pass what they want to pass from a substance perspective, but it's 118 and 59, except for the very few competent ones in there. Most of them are ridiculous. Even a lot of Republicans are morons. So that's it, you guys. I don't have anything else to add. We'll wait for the judge to give us a ruling telling us whether or not they're going to reinstate our case or we go up on appeal. We will let you know as soon as it happens. Okay. Anything else, Bryan?
Nope. I think that's it.
Okay. Appreciate it, you guys. Have a good night. We'll talk to you later.